Merci. Excellencies and delegates, dear colleagues, I'm very pleased to contribute to this event. Many thanks to UNCTAD for this invitation. My organization, CADTM, Committee for the Abolition of Illegitimate Debt, has been working on the specific issue on voucher funds for 10 years. In 2008, we pushed hard for a law here in Belgium that protects development aid from being seized by creditors. Since then, we have worked closely with other civil society organizations in other countries in the south, but also in the north, like in UK, prior to its adoption in 2010 of the UK legislation to protect HIPC countries against voucher funds. However, since then, the international context has changed radically. Voucher funds now don't attack only the poorest countries. They haven't taken advantage of the lack of an international legal framework on the sovereign debt restructurings, meaning that there are no limits to their activities. All the countries are potentially concerned. The case of Greece, attacked by voucher funds in 2012, is a good example. This is why, in Belgium, we worked for 3 years, from 2012 to 2015, on national legislation that adopts a new approach in response to this global evolution. To achieve this, we worked closely with lawyers and judges. Eventually, in July 2015, a new anti-voucher fund law was passed by all the MPs in the Belgian Parliament, which is very rare indeed. This new law is supported by the main debt campaigners all around the world and also by the current UN experts on debt and human rights in an official statement. The last report of the Human Rights Council Advisory Committee on Voucher Fund Activities, presented to the Human Rights Council only last month, also cites the Belgian law as an exemplary of national regulation and recommends other states to adopt similar legislation. Even if the Belgian anti-voucher fund legislation implements a key recommendation contained in several resolutions of the UN Human Rights Council, but also in documentation by the group of the G77 and China, the UN General Assembly, the Parliament of the Council of Europe, this law is now being challenged by a voucher fund, NML Capital, which is based in Cayman Islands. This voucher fund is owned by the investment fund Elliott, well known as one of the biggest voucher funds worldwide. As you will be aware, Elliott won the so-called trial of the century against Argentina. In the past, Elliott was successfully sued countries such as Peru or Congo-Brazzaville. Now, this fund is asking the Belgian Constitutional Court to revoke the Belgian anti-voucher fund law. The main objective is to dissuade other states from adopting similar regulations on voucher funds. The CADTM and two other Belgian civil society organizations, CNCD and LFLF, immediately reacted to this attack on democracy by presenting a request to the Belgian Constitutional Court to be allowed to present legal counter-argument against NML. Our goal is, of course, to preserve the law. In its case, NML raised three main arguments. The first related to the right of property. NML argues that the law breached this right. This argument, as we explain in our counter-argument, is manifestly wrong, since the Belgian law allows voucher funds to recover what they paid for sovereign debt bonds. The law only sets limits on what are considered excessive profits on sovereign debt bonds by creditors, where these limits are based on criteria defined precisely in the law. The second argument put forth by NML refers to the principle of equality and the interdiction to discriminate. NML say that the current law establishes a wrongful discrimination between creditors of states and creditors of individuals. This argument is, in fact, emblematic of the actions of voucher funds which seek huge profits without taking into account the impact of their actions on populations. As we all know very well, states are special debtors since they have legal obligations towards their population. They must respect and defend, including social, economic, and cultural rights. NML furthermore argues that the law allows for the discrimination between creditors that pursue an illegitimate interest, according to the words used in the law, and creditors who are legitimate. In other words, NML aspires to play legislator, when it's, of course, the role of the parliament to act for the public interest and to decide what is legitimate and what is illegitimate. To this end, MPs declared illegal certain behaviors which until then were considered abusive, immoral, but were still legal. The third argument centers around the absolute respect for contracts. This argument is overly simplistic and fails to take account of real-life complexities. As you know, respect for contracts is not unconditional or absolute. Even NML, in its case, admits that national laws can regulate this principle. As the UN expert on debt and human rights recalled in his 2015 report to the Human Rights Council, there are several limits to the respect of contracts and, consequently, to the payment of debt. Legal arguments such as state necessity, recognized by tribunals, and considerations of equity, bad faith, all limit the strict application of the principle of the respect of contracts. The doctrine of odious debt is another such limit to the debt payment, as Professor Robert House developed in a paper published by UNCTAD in 2007. To identify this odious and other irregular debts, audits should be conducted by debtors. The guiding principles on foreign debts and human rights adopted in 2012 expressly recommend these audits. To conclude, I would like to thank again UNCTAD for the opportunity to speak on the recent developments here in Belgium and on a law which is a source of inspiration for other countries. In view of mounting debt problems and potential debt crisis, in particular in the countries of the South, it is very important to act and to ensure that sovereign bonds will not be bought up by vulture funds in many such cases much below their face values. National laws against vulture funds should therefore be considered an urgent concern to prevent the situation from further deteriorating, in addition to moratoria on the payment of all unsustainable debts. We would also argue that unsustainable debt should incorporate human rights obligations to ensure that debt service does not undermine the enjoyment of human rights, as the UN expert on debt and human rights recommends. Let's recall once again that the state's first duty is to guarantee their people's economic and social rights, and this duty has precedence over its obligation to repay its debts. Thank you for your attention.